Hello, my name is Attorney Ramsey Bahrawy and welcome to Your Money, Your Life. Today's segment is about the hope that is provided by VA aid and attendance benefits. Seniors are facing unprecedented challenges when planning for their long-term care needs. People are living longer, are more likely to need long-term care, and will face higher health care costs. Now let's talk about trusts in the context of the VA aid and attendance benefit. A question I'm often asked is whether amounts in trust count as assets or income for VA purposes. Generally speaking, the answer depends on the claimant's control over the funds in trust and whether the claimant derives benefits from the trust funds. There is a three-step test to assist in answering whether the property, including trust property, should be listed in a claim for benefits. The three steps are: first, actual ownership; second, such control over the property that the claimant may direct it to be used for claimant's own benefit; or third, actual allocation of the funds for the claimant's benefit. Generally speaking, the answers to these three questions will determine if assets owned in trust must be listed on an application for aid and attendance benefits. If a veteran established a trust, the property held in that trust is not countable until it is actually allocated for the claimant's use, unless the claimant possesses such control that the claimant may direct it to be used for the claimant's benefit. In other words, in a trust, any portion of the property made available for the veteran's use is countable income for VA purposes. However, irrevocable trusts established for the benefit of someone not residing with the claimant are treated completely differently. For example, where a pension claimant inherits shares of stock and during his or her lifetime places them into an irrevocable trust for the benefit of his or her grandchildren, the stock represents income to the claimant in the year received, but the trust assets are not countable as net worth because the claimant retained no right or interest in the property. Unlike Medicaid, VA does not have a look-back period for the disposition of assets in trust so long as the veteran does not have a right or interest in the trust. As regards special needs trusts used to protect the assets of an older adult, the VA will consider the funds held in a special needs trust when determining a claimant's net worth. As the rules for qualification under Medicaid and VA aid and attendance are different, due care must be used when transferring assets to qualify for either program. Also recall that one tool for long-term care planning, a special needs trust, does not reduce the countable net worth for VA purposes. The only similarity is the rule regarding irrevocable trusts to which the applicant has no right or access. As regards powers of attorney, it is important to note that the VA does not recognize general powers of attorney executed under state laws. The claimant may appoint a VA-accredited attorney. Similarly, the VA will not necessarily allow a state court-appointed guardian to file a claim on behalf of an adjudicated disabled claimant, nor will it automatically allow the guardian to be the claimant's representative payee for pension benefits. In the case of an incompetent claimant, the VA has broad power to select and appoint a fiduciary to receive pension payments on the claimant's behalf. The claimant should, even if adjudicated incompetent, sign each application document to the best of his or her ability. The VA allows incompetent claimants to prosecute claims for benefits even if a fiduciary is ultimately appointed to receive the payments. In conclusion, the veteran's benefit can play a crucial role in the planning for long-term care. It can provide a lifeline that holds out hope to a veteran and his family. To review, in order to receive the enhanced monthly pension, an applicant must first establish the requisite military service, limited assets, and total disability. In addition, the claimant must demonstrate the need for regular aid and attendance of another person. The need for assistance of another person must be regular but need not be constant. Be warned, however, that the application process can be cumbersome and daunting. The VA system has its inherent problems which can be frustrating. As aid and attendance is a means-tested program, any income, unless specifically excluded, is counted, and net worth is counted to the extent that it can reasonably be expected to provide for the claimant's care. Also expect that sometime in the future, Congress may tighten these means-tested qualification rules by making them more consistent with the Medicaid requirements. Don't forget that for a veteran's asset protection estate plan to be effective, it must consider and address both the Medicaid and VA requirements. That is our show. As always, thank you to our viewers for watching Your Money, Your Life. My name is Attorney Ramsey Bahrawy, Building Your Trust.